And even in the complaint, when you read the allegation is, fired because of this retaliation and racial discrimination. So again, I think you're right, Anthony. Like the smell test, when you read it, is like, well, obviously she was fired because of that. But
Yeah.
again, we're at the pleading. I'll note one thing. I mean, so this wasn't in the complaint. It was actually discussed at oral argument that Sergeant Kushal was sued civilly by the off-duty officer, and that resulted in a $5.2 million jury verdict with an additional $2.1 million in attorney's fees that the city is paying. City represented Sergeant Kushal. So we're now talking about a $7 million cost. This officer is still on the force. And here's the kicker. An internal investigation into his conduct found that the use of force was reasonable and there was no de-escalation technique. So like, it's really kind of frustrating, I will say, to read this and to kind of see like the lack of accountability from internal to the police department when it's so difficult to get accountability externally when you sue officers, for violations of your rights.
Wow.
Oh my
So that's the
gosh.
kicker.
So that's not this plaintiff. That's the woman who was actually hit by the punch.
Correct. The
Filed
off-duty
that
police
lawsuit.
officer. Yeah.
Shady towing practices in the city of Detroit, and a punch-up at a bachelorette party in the city of Baltimore. All that, plus a preview of the circuits, this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, January 14th, 2026, and I have two of my Institute for Justice colleagues here to discuss these cases from the Sixth Circuit and the Fourth Circuit about some practices that go on in cities that are known to have an most outstanding reputation when it comes to public integrity and crime. So we'll get to those in a little bit and my colleagues. First, a little preview. So we feel here on Short Circuit, last almost 11 years now, we at times have not done a great job talking about what we talk about, which is the Circuit Courts of Appeals, the federal appellate courts. And so we have a little series this year that we'll be doing, and that is 12 months, 12 circuits. So each month, we're going to take not a huge episode dive or like a whole episode or anything like that, but just a little peek into each of our federal circuits so we can let our listeners know, especially our non-lawyer listeners are probably like, Fifth Circuit, what does that even mean? Like, who's there? Where is it? What does it do? So we're going to take one by one all of the circuits over the next 12 months, starting with this month, the First Circuit, number one, right? January. So we're going to do, there are 11 numbered circuits. So we're going to go 1 through 11, First Circuit through 11th Circuit. Then we're going to squeeze in the DC Circuit in December. Now, I know some of you lawyers, especially out there, are thinking, wait a minute, there are 13 circuits. You said 12 months, 12 circuits. Well, there aren't 13 months in a year, right? So the 13th circuit, so to speak, is the Federal Circuit. And we are very upfront here at Short Circuit that we do not cover the Federal Circuit. In fact, at times we have advertised our newsletter as we cover all the circuits except the Federal Circuit. And that's because the Federal Circuit says a lot of things that we don't understand. Most of its docket has to do with intellectual property. It also does a few other random stuff. Now, I will say at times we have covered the Federal Circuit. We've done on occasion in the newsletter and on the podcast a Federal Circuit case. We talked about the tariffs case when it was at the Federal Circuit a few months ago. It has this kind of specialized docket. But anyway, 12 months, 12 circuits. But I want our Federal Circuit fans to know we are going to be doing the Federal Circuit. Okay, but it's kind of going to be a wild card. We got to squeeze it in at some point in the next 12 months because we can't have 13 months. That just looks weird, right? A baker's dozen of circuits. So we will get to the Federal Circuit and we will do all the other circuits. And we will start with the First Circuit today, but we're going to do that at the end of the show. It's just going to be a little thing, about 5-10 minutes, discussing the First Circuit. But before that, we have the Sixth Circuit and the Fourth Circuit in some of their latest opinions. So Kirby Thomas West, who knows her way around Detroit corruption and crime, is more than almost anyone else these days, is going to discuss this case out of the Sixth Circuit involving shady towing practices and car theft. So it's kind of a Gone in 60 Seconds kind of theme. So we'll get to that in a little bit. But first, I want to introduce a first timer who's on Short Circuit, who is going to be discussing this Fourth Circuit case about a bachelorette party and a punch-up and racial discrimination a little later. But first, I want to introduce Carl Wu. So Carl is an attorney now at the Institute for Justice. He's joining us here for a little while. But before that, he worked at the big bad firm of Skadden Arps. He also clerked for a judge on the Western District of Texas, Judge Xavier Rodriguez. He went to Rutgers at undergrad, and then he went to Brooklyn Law. But along the way, he was a paparazzi photographer. So I'm interested in hearing what he has to say about the life of photographing famous people, and also how that compares to being a lawyer.
Yeah, Anthony, well, happy to be here. So I started doing it when I was 12. I used to collect memorabilia. I was always into photography, and one day I just picked up a camera, took photos. It was like Angelina Jolie leaving an art shop, sent them into magazines, say, hey, you want to buy these? They bought them.
Wow. And so you lived in New York, right?
Correct. Yeah, I grew up.
So it's kind of easy to find famous people. So you just kind of like run around and
basically
take pictures on,
the
like,
first
figure out
famous
your own
person-
plan.
Yeah, the first famous person, I was walking in my violin teacher's house for a lesson. The David Letterman show was right on her block, and so I would pass by it, and that was kind of the intro to that life. And yeah, I did it all throughout high school. After high school, throughout college, full time for a little bit in between. And basically, I would be on my bike all day. I would kind of ride around the city, look for people, get tips, get information. Obviously, very different to the lawyer life, where I'm not on my bike and I sit in a room and read all day long and write. But I will say there's a lot of research involved in both, right? So we used to kind of look for people, and we would have kind of keywords. We would be on Twitter and, spotted here, spotted there. And so that kind of attention and, constant monitoring. So, let's say here you have argument, make sure there's no new cases that pop up right before. So that research, I think, tracks both careers.
Did you ever have moments, like occasionally the celebrity just can't take it anymore and they take a shot at the photographer and knock it out of your hand? But did that happen?
That happened once. Wasn't my camera, but it did happen once. The guy from Avatar got into a little kerfuffle.
Okay.
In New York.
Okay. Well, we'll leave it at that, perhaps.
I have a new podcast idea, Anthony. I think you should do a new podcast called The Secret Lives of IJers, because I always joke with new IJers that I am the least interesting IJer, because so many of our colleagues have really interesting histories or interests. Anthony, you very much included. I'm delighted by this, Carl. Happy to know this new information about you.
Yeah.
Well, we can get a little of that, I will say. I heard a rumor that, Kirby, that you're going to be appearing on our one of our sister podcasts, Unpublished Opinions.
Yes, that is true.
At times, and so maybe we'll hear how interesting you actually are, which I think you're holding.
Not
something
very,
back there.
I'm afraid to say, but I'll do my best. I'll have to develop something cool about me before that starts.
Well, the cool thing, I mean, this is true of IJ, but it's true elsewhere too, is law school is filled with people who had a different career that for whatever reason they couldn't make it at, or they didn't want to do it anymore, or they want to actually be able to, pay the rent. And so they go to law school, but it's filled with all these, interesting backgrounds. And so we like exploring that from time to time here on Short Circuit. But we also like exploring the federal courts of appeals, including this case from the Sixth Circuit about a tow truck driver who just happened to be in the right place at the right time too many times, and nevertheless, even with those shady practices, won a judgment against the city of Detroit. And what did that get them, Kirby?
Not very much, but I want to start by first clarifying when Anthony says that I am very familiar with corruption and bad practices in the city of Detroit, it's because I'm opposing those things.
Oh,
I'm on the good
sorry
side
for the
of
confusion
this.
there.
But Wayne County, Michigan, as longtime listeners might know, and all IJers know, is my number one nemesis here at IJ. I have a number of cases against Wayne County, including our Detroit forfeiture case, which is about vehicles in Detroit. So everybody should separately look into that case. But here we have a towing company who had a contract with Detroit to recover stolen cars. And so what they would do is recover the stolen cars. They would charge a towing fee to the owner of the cars for the car's return. And there, as Anthony, you previewed, some things that they were doing started to raise some questions. So specifically, it seemed like they were finding these stolen cars pretty quickly. And when I say pretty quickly, there's one instance in which Detroit Police Department had video of a Jeep being stolen at 7:05 a.m. At 7:19 a.m., that vehicle was recovered by Nationwide Towing. This is 14 minutes later, and the tires of the Jeep were already stripped by that time. Now,
I'm just impressed they could do all that in 14 minutes. They could steal it, get it somewhere else, get the tires off, and be gone.
I had the same thought, Anthony. I've changed a tire before. It took me like that long to change one tire. So an officer with the Detroit Police Department was like, this seems a little strange. And he started looking into this a little bit more, and he found other evidence that this particular towing company, Nationwide Towing, had just an outsized number of recoveries of stolen vehicles compared to the other companies that had contracts with the Detroit Police Department. He recommended that the contract be suspended or terminated. He sent that to the Board of Police Commissioners. When he sent it to the Board of Police Commissioners, the board, at the advice of the Department of Law, said, actually, it looks like we didn't actually have the authority to issue permits in the first place. We think that this whole process was a little bit mixed up, and since the permit was probably invalid because we didn't have the authority to issue it, we don't really need to do anything process-wise. We can just terminate the permit and be on our way. The procedures that had been kind of passed for that they were supposed to follow and been part of the contract were the companies were entitled to a pre-termination hearing if the contract was going to be terminated before the 5-year term, unless there was some kind of fraud or criminal activity. At that point, the termination could be immediate, but they were still entitled to a post-termination hearing to confirm that whatever wrongdoing had actually happened. Here, the company didn't get either because, again, the police commissioner said, like, whoops, actually, we weren't supposed to be doing this anyway. We don't have the authority to issue these permits. The company sued Detroit for the termination. They said the wrongful termination of their contract, and they sued for compensatory damages in the amount of $103 million.
Wow, that's a lot of toes.
That's a lot of toes. That's a lot of toes. They recovered, however, only nominal damages because the court below said there might have been a due process violation here, but you cannot show that you're entitled to any kind of compensatory damages because, frankly, your contract would have been terminated anyway, even if they had followed the correct procedures. Now, the reason the district court said this is because there was a lot of evidence that they were engaged in criminal conduct. Specifically, again, there's this initial thing that tipped off the officers of the 14 minutes between the stolen car and the recovery of the car. There was just the outsized number of cars that they were taken. One tower in particular at the company was, over a 1-year period, was recovering 13 stolen cars per week. That was only one person, one tower at the company. They also, so they found another instance in which it was like 5 minutes between the theft and the recovery of the car, so even quicker. And then really the icing on the cake is they recovered the phone of a car thief in Detroit who had been texting with this high-frequency tower, Kenneth Turbo Christian. I think if you're hiring somebody that goes by the name of Turbo, that should raise some red flags already, personally.
He might be really good.
Oh, that's true. Poor Turbo, though. I don't think he had a great relationship with this car thief. He was a little bit mean to him in these text messages. He said things like, "Come back and get your money, Dillhole," and "Do some work, Twinkle Toes." But these text
Who
messages,
says twinkle toes these days?
kind of refreshingly wholesome from a car thief, I think. But this obviously kind of implicated him that he had been, in fact, not only getting tips from car thieves, as he later acknowledged that he had done when he was asked questions about this, though he said that once his supervisor told him to stop taking tips from car thieves, he did stop doing that. So the supervisors knew at least that he had been taking tips, although those tips were also, I think, monetary, not just, verbal tips. And there was all this evidence that the company had done this. Now, there was also an internal investigation by the Office of Internal Affairs at the Detroit Police Department that found that they had done nothing wrong. However, that in a footnote of the Sixth Circuit's decision, they said that investigation was hardly rigorous. And in fact, some of the deposition testimony showed that the officer who conducted the investigation had not read the memos from the initial investigators showing that, again, this 5-minute gap in theft, or that these text messages, he was not even familiar with these pieces of evidence. So even though that internal affairs investigation concluded there was no wrongdoing, simultaneously there was a criminal investigation into this that showed, again, all this evidence that, in fact, Nationwide had not only been getting tips of how to get these cars and working with car thieves to collect more cars to get towing money, they had also been overcharging the towing fees by hundreds of dollars. And they had, sometimes they would charge the owners of the cars for the return, but where they were charging the city fees, where they were charging fees that went to the city, they would charge $100 extra that would go in their pocket and then give the city the rest of it.
And then they had this side gig with the guy's
Yes.
brother's auto shop. That
Yes.
was really shady.
Yes. So in one instance, they told an owner, okay, well, you could pay this $700 fee to get your car back. However, we'll waive the fee if you take your car to this auto shop. The auto shop happened to be owned, again, by someone who had a 75% stake in Nationwide Towing. So it was a family member of the person who owned and operated Nationwide Towing. So this was pretty extensive fraud scheme. And I think just wow, the brazenness to then sue the city of Detroit for damages after you've done this. I'm just wow, that's, pretty bold, I will say. They sued. Again, they got just nominal damages because they couldn't prove this compensatory damages, in part because the district court found their contract would have been terminated anyway, and in part because they had been overcharging fees by so much that the district court said, you really aren't entitled to compensatory damages because you've been getting too much money this whole time anyhow. The Sixth Circuit affirmed on appeal. The issues on appeal were, one was summary judgment, properly granted on the issue of no compensatory damages, and had the district court properly denied a motion to strike. So the towing company had moved to strike a declaration from one of the officers who had investigated, saying basically he had given impermissible legal opinions. For instance, he had described their conduct as fraudulent. The Sixth Circuit said no, that the motion to strike was properly denied, and this was not a legal opinion. And then affirmed that, applying this two-step analysis of what were compensatory damages properly denied, of one, would the same action have been taken anyway, and two, are there any proof of actual injury sufficient to support compensatory damages? Under both of those factors, compensatory damages were properly denied, and so affirmed. But the whole case, I think on the legal front, maybe less interesting, but just on the factual front, it just, this city, I'm telling you, if you go to Detroit, it's a lovely city. You could just see, there's so much promise there, right? This beautiful Art Deco architecture. It's got a lot of character and charm in parts, and just completely plagued by corruption and bad behavior, which the Institute for Justice is trying to rectify. But My goodness, this not a great look. Not a great look. Although
but
happily not the government. Exactly.
The city did do the right thing here.
That's true.
Eventually.
Yes.
Yeah.
Credit where it's due. They did the right thing eventually. After a couple years of rampant fraud, they managed to figure it out. I know we're going to be talking about Baltimore next, but I will say this also reminded me, for viewers of The Wire, the text message from the car thieves in particular reminded me of, in less colorful language, a famous quote from The Wire. "Are you taking notes on a criminal conspiracy?" Free
Very
legal
much,
advice.
Yeah.
Don't do
very
that.
much like that.
Yeah.
Carl, your thoughts?
Yeah, I mean, I think one thing that this case does reaffirm, is that process is important in itself. It relies on that Carey v. Pifus case, which shows like here, obviously in the end there wouldn't, have been any other finding. They would have gotten terminated, but it's a nice, affirmation that the process is separate. It protects people who not only in the wrong, but also in the right. And so we often rely on that case, I think. I think Nationwide is still operating, not in Detroit, but in other states. So hopefully they have fixed whatever issues they have in those other states. But I guess one other thing I'll say is, oftentimes I think you think liability, you kind of forget about damages. Here obviously $1 in damages, but often you kind of miss out on that point when you're thinking.
Yeah, and that's a good reminder, Carl, that this case, Carey versus Pipus from the 70s, where the Supreme Court said if your procedural due process rights are violated, then your ability to get nominal damages, so symbolic damages, is absolute, I think is the word they use. So if you're denied this hearing, even if you're guilty 6 ways to Sunday, that is a violation of your rights. You can get a judgment, but it's not even going to probably buy you a cup of coffee, because it literally is going to be $1. And also, so this does not get into at all, Kirby, attorney's fees. I'm guessing they may or may not have moved for attorney's fees at this point. It may have been stayed while the case is on appeal, but attorney's fees are themselves not automatic even when you win a judgment. I think they probably have absolutely no chance at attorney's fees here, even though they did win a Section 1983 case.
Yeah, I would think it would be a pretty uphill battle. One minorly, I think, interesting legal point that was noted in this opinion was under this test of, like, are you entitled to compensatory damages or are you not for a due process violation? So the first part is, like, would this have happened anyway if process had been given to you? And I think I appreciated that the court noted when we're looking at this, we can't allow post hoc rationalization. So, like, other things that they couldn't have known at the time, like the city could now come up with other evidence that, like, oh, we would have done it because XYZ that we found out in this litigation or something like that. It has to be based on the information that was available at the time. And I think that was a good thing for the court to note, that not to use a case like this with such bad facts to make it harder for someone to get compensatory damages where they really are entitled to them for a due process violation.
Yeah, good point, because bad facts can make bad law, but the court was careful here to not make that bad of a law, unless you're as bad as the plaintiff apparently was here. So more of a mix of bad and good, and I, to tell you the truth, can't even tell exactly what's going on, is this case from the Fourth Circuit, which is about a racial discrimination claim, a retaliation claim, and then there's claims that I'm kind of confused weren't even brought. So we'll take a step back from all that. But Carl, please tell us the story of this bachelorette party in Baltimore that got a little bit out of hand.
Yeah, Anthony. So this case, it's Johnson via Baltimore Police Department, or BPD for short, out of the Fourth Circuit. And it's really an employment discrimination case. It kind of shines a light on intra-Baltimore PD issues.
Yeah, it really is like The Wire. I mean, it's like nothing's changed. That was 20 years ago.
And throughout the case, it gets worse and worse. And so the plaintiff here is Wanda Johnson. She was a 14-year veteran on the job, and she basically alleges that she suffered racial discrimination and retaliation because she was forced to resign after some sustained disciplinary charges. And so we're on a motion to dismiss here. So we're going to, take the facts as true as alleged. And the story starts back in 2018. Ms. Johnson was having a bachelorette party at a nightclub in Baltimore, and there was kind of a bar fight altercation outside the nightclub where a member of her party, an off-duty Baltimore police officer, ended up getting punched by an on-duty police officer, Sergeant Kushal. Now, Sergeant Kushal was eventually arrested for this. He was charged with second-degree assault misconduct. That conviction was affirmed by the Maryland Supreme Court. And so you might think after all of this, well, he would be the one who would be terminated. That is not correct. He is actually still on the force, at least as of oral argument. And so instead, Ms. Johnson was investigated. And so kind of backing up a little, so during Sergeant Kushal's investigation, Internal Affairs investigated him. Ms. Johnson testified before the grand jury. This was in 2019, and then a couple months later at his trial as well. During those two events, Internal Affairs started an investigation into her, Ms. Johnson. They said that she alleged to have made a false statement, that she was actually the one who assaulted someone at the nightclub, and that she failed to report this. So this investigation took a little while, about a year later, and so the Sergeant Kushal is already convicted. Internal Affairs interviewed her. There was some other state court litigation where she was trying to block the investigation. That was unsuccessful. And so then they filed these disciplinary charges. Following these charges, she was suspended, but with pay. So then after that, so we're now in 2020, about a year later, she files an EEOC complaint, basically saying she was discriminated against and retaliated by being suspended. And again, she pointed here, and this is going to be critical, to other white officers who also made false statements who were not suspended. Nonetheless, despite this complaint, the disciplinary charges proceeded. She had an administrative hearing, and the charges were sustained. Now, this administrative hearing raised some more problems because, according to Ms. Johnson, the testimony that she was the one who assaulted someone was a false report filed by another Baltimore PD officer. And she alleges that the Internal Affairs investigator, who was kind of the one who shepherded this hearing along, made also false statements at this hearing. So then after the hearing, charges were sustained, and she alleges she was forced to resign. The next day, she files an internal complaint about this conduct at the hearing. Let me back that up. So then after the hearing, she files this complaint about the conduct at the hearing. The day after she files the complaint, she alleged she was forced to resign. So a year later, she files suit in federal court, and she brings a Title VII claim for racial discrimination, again, going to those other people who she says committed all other false statements, who are not fired, who were white. Retaliation claim. She brought a Monell claim as well, basically alleging First Amendment retaliation, but basically the only allegation she had was the events of this case, and then an analogous state law claim for discrimination.
Right. And she doesn't sue any individuals, right? It's just the city of Baltimore.
It's just the city
for
of
all these
Baltimore.
claims. Yeah.
Correct. And so at the district court, the first complaint was dismissed with leave to amend. She filed another one. District court dismissed all of the claims. And so we're now at the Fourth Circuit. The Fourth Circuit reversed the district court on the Title VII claim and affirmed the rest. So for the sake of time, I'm just going to focus on that Title VII. I'll just note briefly the retaliation claim was affirmed because basically they said you didn't kind of meet the causation inquiry. The protected activity is the EEOC complaint, not what you might think intuitively actually is the testimony against another officer. And so that claim was gone. And the Monell claim, you have to kind of show a policy, practice, and that just wasn't alleged because there was...
And basically they say kind of the fix was in against her before she filed the EEOC complaint. And so you can't point to the EEOC.
Correct. Yeah. And so that Title VII, you might think there's a standalone kind of First Amendment claim outside of the Monell claim, perhaps, but that wasn't brought. And so basically the Title VII claim is what's at issue. And I'll just set the stage. So, right, Title VII, it prohibits an employer from discharging any individual or otherwise discriminating on the basis of race. And so we're on a motion to dismiss. And so the standard really here is, plausibility. You just have to plead facts that go above a speculative level. But employment discrimination is often hard to plead. You never have this kind of smoking gun evidence of racial discrimination. And so courts adopt at the pleading stage, as well as at the summary judgment stage, and that's heavily disputed, this McDonnell-Douglas kind of framework, all right? And so McDonnell-Douglas can be useful, I think, at motion to dismiss stage because it helps kind of frame the complaint, especially if you don't have that direct evidence, because you're basically allowed to point to comparators and say, look, these people did the same thing. They were engaged in similar conduct. They weren't fired. I was fired. That's a kind of plausible allegation.
Right. They're not my race, and so therefore it's evidence that I was discriminated against because of my race.
Right. And so, again, at the pleading stage, you don't need to, maybe make this whole McDonnell-Douglas prima facie case, which looks to, membership protected class, satisfactory job performance, adverse employment action, and similarly situated comparators. And I think the dispute here between the majority and dissent is kind of how specific do you need those comparators to be? So the district court dismissed the claims, even though Ms. Johnson pointed to 13 comparators. These were white and non-black officers who committed misconduct, and this is quite a list, using racial slurs, multiple DUIs, fleeing the police. This is officers fleeing other officers. Excessive force against the public, domestic violence, assaulting other officers, disorderly conduct, tampering with investigations, and the kicker, multiple false statement allegations, which is what Ms. Johnson was allegedly terminated for, as well as the assault. None of these officers were forced to resign. But the district court held that they weren't similar comparators, even at the pleading stage, because they didn't have that adjudicated finding of disciplinary charges. So the Fourth Circuit majority said, no, we don't need this kind of one-to-one match at the pleading stage. There are sufficient facts. Oral argument, said maybe you only need one or two, right? There's 13 here. And kind of took a higher level of generality. And so under that standard, the comparators were all officers. They had same offenses. And they were all kept on the job while Ms. Johnson was terminated. And so basically the idea, is that, look, even if you have a lot of rotten apples, again, Ms. Johnson contests that, you can't just fire the black one or, the one who's not white. And that's discrimination, treating people differently. And so this case will go back down for discovery. I would assume it might settle. This will be pretty voluminous discovery into the internal investigation practices of the Baltimore Police Department. But that might be even more revealing. I will say, so Judge Wilkinson has a dissent. And so he, makes 2 points. First, he adopts the district court's idea of you need this kind of strict comparison. He thinks the idea of a, adjudicated finding is, determinative on a motion to dismiss. But then he makes this other point where he basically talks about the kind of internal functions of police departments and how they operate on a theory of trust. And, courts should kind of defer to the kind of internal adjudications of police departments because, they're really trying their best. And this has kind of set them back. Kind of what seems to be like a Title VII claim will set back the police department's kind of inner workings. I'm not that sympathetic to that position. I think the majority is right here. Again, we're at the pleading stage. You don't need that one-to-one match. You might think, the closer fit you need, you kind of implicitly credit the reason for the termination, right? And that's the whole point of discovery, because maybe the adjudicated finding is a relevant factor. Maybe it's not. Maybe it's all pretext, and they're only sending, non-white people to adjudication or something like that. He has a line in the opinion where he says, because the claim will fail on the merits, we shouldn't kind of, let this play out against the Baltimore PD. Again, motion to dismiss.
Yeah. And he seems like a pretty thin reed why he thinks it's like he's looking under the hood. He has this he makes this big point about how the guy who was convicted, that cop, is actually black, even though there's something in the record or in the allegations alleging he isn't black. But I mean, even if he is black, you can still have these comparators. It's not like you have to allege you're the only person of your race to have your protected class to have, nothing that bad things have happened to. In any case, thanks for that summary, Carl. This is, again, I am still very confused as to what's actually going on here. But Kirby, can you help me out?
I don't know if I can help you out, but I did the Wilkinson dissent made me think of the case we just discussed out of the Sixth Circuit when he says like, oh, we should trust the internal affairs of police departments and things like that. It's like, oh, the internal affairs officer in the police department in Detroit looking into this towing scam couldn't be bothered to read the memos about the fraud. So he found, nothing wrong here. Luckily, there was the criminal investigation that, kind of undermined that and showed all this evidence. But I don't know that, like, we should just assume that all these internal affairs investigators are doing a great job. I'm sure many of them do, but I don't think that it's proper, obviously, for the court to say they can do our job for us. We could trust them so much that we can just, not bother looking into it at all. The other thing I'm sort of reminded about when we're talking about this case and how Title VII works is in finding these like comparators. It almost like rings of like qualified immunity analysis of where you have to find, like, are you going to be held to find something that's exactly the same case as yours? And just how tricky that is, because that's not how real life works, right? Like different people are different and different circumstances are different. And I think it's just unreasonable, both in the QI context and here, to say the people that you're pointing to, have to be exactly the same as you in exactly the same situation in every possible context, except that they're white and you're black. Like, that's just totally, impracticable.
And they're both their kind of judge-made doctrines, right? That kind
Right.
of put the scale, put the thumb on the side of the defendant, employer, officer.
Right.
One thing I will say, to Judge Wilkinson's point, I mean, his whole philosophy, or a lot of it, kind of is rooted in this kind of restraint and kind of trust in kind of democratic political process and let that play out. I don't really know how that tracks to like internal affairs of police department adjudications. I mean, yes, executive, branch or whatnot, but like Title VII, originally it was for private employers, but Congress specifically amended it for public employers, right? So it's supposed to be, applicable to officers to the extent, you're thinking about like judicial role or whatever. If Congress is explicit and this should apply, to then take a step back and say, well, let's kind of give them some breathing room.
Yeah.
Not sure how that.
Yeah,
tracks.
it's a judicial gloss, right?
Yeah. And I think it's messier once you get to like the summary judgment stage, or you're getting to like a final determination in the case of how do you actually, like, what evidence do you actually need to marshal to show that this is racial discrimination? Like, that can be more difficult, I think. But at least at the pleading stage, it seems like, they should, there shouldn't be such a heavy burden at the pleading stage to just get to discovery and show, like, try to make your case.
Carl, let me kind of open the hood here on my confusion of the case, and I think what you said in your presentation is helping me out here. So what I was confused about is it seems like maybe there's racial discrimination here. Maybe. I think probably what's going on is the Baltimore Police Department is as corrupt as it is portrayed in the Wire. And so for so she was, and they talk about it in here, she was blackballed. They quote that word. She was blackballed because she testified against this cop who, it seems like, legitimately did a really bad thing, which is took a swing at someone who was part of this bachelorette party. They don't say if the victim was a female or a male or whatever, but it seems to have been a non-policeman who was just part of this party.
It was a female. Yeah.
It was a female. Okay, you're right.
Yeah.
So like, that's bad. And he was punished, and part of the process for the punishment was her testimony, the plaintiff's testimony. So it's easy to see that there could have been all kinds of repercussions, especially because this prosecutor told her that, it was that the storm was coming for her, basically. So but she doesn't allege that as protected, like a protected speech as far as her retaliation claim. And it just dawned on me when you were explaining the case. I'm guessing that's because this is a Title VII retaliation claim. And for that, you need to like point to the actual EEOC complaint. But for a First Amendment retaliation, you could talk about your grand jury testimony. But then if she sued like these individuals, she'd have to worry about qualified immunity. And she tried against them, the city of Baltimore, for a Monell claim, but she wasn't able to prove like a pattern or practice. And so then she has to do this kind of like weird workaround that turned out to not work very well. Am I right?
Yeah, that's right. So actually, in the district court on the first complaint, she argued that the protected activity for the Title VII was the testimony. District court rejected this because that's not considered. Even though intuitively you might think like, it should be protected. I'm in the employment space and I'm testifying against another officer. No, it's the complaint itself. And so that was the causation inquiry because the investigation started before the first complaint.
Yeah, I think, Anthony, that clarifies it for me too, because I definitely had the same question where I'm just like, this is a First Amendment retaliation case. I mean, maybe there's also racial discrimination. And like I said, I think, with all those comparators, you should at least get past the pleading stage. But it does seem just like, okay, you read the facts, like we could all see what's going on here. But I think you're right that it's like the hoops that you have to jump through to vindicate constitutional rights against individual officers are so ridiculous that I can understand why someone would feel like funneled into this Title VII claim instead.
And even in the complaint, when you read the allegation is, fired because of this retaliation and racial discrimination. So again, I think you're right, Anthony. Like the smell test when you read it is like, well, obviously she was fired because of that. Yeah. But again, we're at the pleading. I'll note one thing. I mean, so this wasn't in the complaint. It was actually discussed at oral argument that Sergeant Couchal was sued civilly by the off-duty officer, and that resulted in a $5.2 million jury verdict with an additional $2.1 million in attorney's fees that the city is paying. City represented Sergeant Couchal. So we're now talking about a $7 million cost. This officer is still on the force. And here's the kicker. An internal investigation into his conduct found that the use of force was reasonable and there was no de-escalation technique. So like, it's really kind of frustrating, I will say, to read this and to kind of see like the lack of accountability from internal to the police department when it's so difficult to get accountability externally when you sue officers, for violations of your rights.
Wow.
Oh my gosh.
So that's the kicker.
So that's not this plaintiff. That's the woman who was actually hit by the punch.
Correct. The
filed
off-duty
that
police
lawsuit.
officer. Yeah. And this incident, and here's the last kicker, apparently went viral. There was a video of this that was online circulating. So not a good look for the Baltimore PD. To Wilkinson's credit, he says they're improving. So we would hope so, right? There was that 2016 DOJ investigation resulted in a consent decree, and maybe things are getting better. But
and this incident was what, 2018? I think this punch.
Yeah, and that's again. I mean, we're talking now. This is 6 years down the line, and we're just starting discovery into this.
8
case.
years. Yeah.
8 years. That's right.
Yeah. So
was the victim like really hurt? That damages seem really high, right? Or no? Like, is that typical for?
So I don't think so. In the district courts, I was kind of parsing the docket, and the district court made a comment. The jury returned an astonishing verdict of 5.2. So liability wasn't contested, and it was just a damages trial.
Wow.
I bet that jury had feelings about the Baltimore PD.
I would
for
think so.
various reasons.
I would think so.
Well, that clears things up for me. So thank you, Carl. So we are going to move on now to so we've done Detroit, Baltimore. Now we're going to be moving on to Boston, right, big city, and then the environs of New England. So little tiny bit of background here about the circuit courts of appeals. So we are always talking about the federal appellate courts. We also call them the U.S. Courts of Appeals, and we have the U.S. Courts of Appeals for the First Circuit, for the Second Circuit, blah, 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 blah. So that whole system of appellate courts where you have like the district courts with district court judges, and then you have the courts of appeals above that where you have judges who are specifically set for that Court of Appeals. And then you have the Supreme Court above that, and the Courts of Appeals take the district court stuff. They also take some administrative stuff and like weird courts Congress has made, other like the NLRB, places like that. But basically, we have these appellate courts. They were established in 1891. Well, what do we have before that? Well, before that, we had the circuit courts. This gets a little confusing. We're not going to do the whole history lesson here, but basically the circuit courts, part of what the circuit courts did was the justices of the U.S. Supreme Court would ride circuit. And they would go around to their circuits, and some would be assigned to various circuits. And essentially, after over 100 years of doing that, they were fed up. They were fed up moving around the country. Actually, pretty much exactly 100 years. And so they got we're just going to have an appellate judiciary, intermediate judiciary to do that. So the First Circuit was established at that time, and it's a little circuit. It's a little baby circuit. It is Maine, Massachusetts, New Hampshire, Rhode Island, and Puerto Rico, which does add to its docket load and the population in its state. So it's basically New England and Puerto Rico, but minus Connecticut and Vermont. It has only 6 authorized by Congress full-time judges. Well, when I say full-time, that full circuit judges. Now, it has senior judges, like all circuits do. When a judge can go senior, usually when they can get their pension, and they're tired of being a circuit judge, they get a little bit of a reduced workload as a senior judge, but you still get a salary. And so they have 5 senior judges. They used to have 6, or maybe they didn't. Maybe they didn't actually have 6 at one time. But anyway, Judge Selya, who we loved in the Short Circuit newsletter because of all the weird words he would use in his opinions that no one had ever heard of. We'd love to summarize those. He passed away last year. So there were 5 senior judges. There was just a new judge appointed and it confirmed last year, a Trump appointee, and of the 6 judges. There were a bunch of Biden judges on the court too. So 6 judges. So that's really small for a circuit. That's I think way smaller than any other circuit. I think we'll get to this over the course of the year, but I think every circuit is at least like 10 or 11 other than this circuit. And so it takes cases from those states. It uses Courier font in its opinions, which I am not happy about, but Carl tells me it's orders. Sometimes now they use Times New Roman. It's not a great font either.
At least one
Okay.
I saw the other day was Times New Roman single spaced, so that was a refreshing read.
I'm still not a fan of Times New Roman, but it is better than Courier.
Better than Courier.
I mean, my goodness.
Incremental change.
Once it gets into the West Reporter, they do whatever they do. But if you're just pulling it off the website, like we do it for the Short Circuit newsletter, it's quite annoying. I'm just going to repeat that once again for our First Circuit clerks who may be listening. So that is the First Circuit. Any nuggets of wisdom you guys have about our little First Circuit? We've litigated there at times over the years. We've had a couple school choice cases pass through there in the last few years, but not a heck of a lot. It is a little circuit.
I've had it. I don't have much to pass on, but the Carson case obviously was in the First Circuit, so it's a school choice case. For law students listening, I don't know if this is true. I think it's true. Occasionally, they do sit in Puerto Rico.
Yes.
So,
yeah,
that
Boston
would
and
be,
Puerto Rico.
That would be an appeal to sit. Appeal. Maybe a wrong word choice. That would be attractive for people considering to clerk on the First Circuit. You might get a trip to Puerto Rico out of it.
Yeah, good point.
They do at times. Historically, actually, the cases coming out of Puerto Rico are actually more in number than the cases coming out of the states. And I was reading an article. It is kind of interesting. Apparently, they were supposed to have their first sitting sometime in the 20s. They canceled it because they said there was not enough cases, but apparently it was because of a judicial illness or something like that. And so it took them a while to then have their first sitting. 20 years later or something like that.
And also with Carl and I were talking in the green room a little bit earlier. They do have an en banc procedure in the First Circuit, but as you might imagine, with only 6 judges, right, that's just double a panel. Of course, the senior judges go on the panels, but there's less kind of crying out for en banc, and they kind of have the system where they can review opinions with each other. They sometimes will reverse an older opinion without going en banc because it's just so small. When you get bigger, things get, as we'll see in future episodes, things get more complicated. Also, finally, each circuit gets a justice who oversees that circuit, basically, to kind of keep tabs on things, be in touch with people, go speak at their circuit conference. But usually how most people run into this is if you ask for an extension of time or some emergency relief from that circuit, it first goes to that judge, and that is Justice Jackson. And I believe she has that circuit because Justice Breyer, who before that was Judge Breyer on the First Circuit, was naturally for the First Circuit, so he was in charge of it. And I think she's just stepped in. In the future, perhaps they'll rearrange as we have more turnover on the Supreme Court. So that's the First Circuit.
He still sits occasionally. I know he did like a sitting a little while ago on the First Circuit. Justice Breyer.
Right. Retired justices can do that. I think Justice Kennedy did it for a bit. I know Justice O'Connor did for a while after she first retired. So it's how they can keep in the game. Well, I think maybe Justice Souter did too, because he was a First Circuit.
I think that's right.
Justice. Mm-hmm. Yeah. So anyway, but there's lots going on in the First Circuit. So there's a lot going on at Short Circuit too, and we're going to hear more about that in future episodes. But for now, I'd like to thank my colleagues and thank you for listening. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.